I'm J.P. Grund from Marietta, Georgia. In the year 2000, my ex-wife's first attorney, Joan Davis, attached the signed signature page of our 20-page divorce decree to a false document and filed it in the courthouse in Marietta, Georgia, with Judge James Botiford's signature and full knowledge of what they had done. My first attorney, Bill Herndon, would later testify to this in a hearing of contempt that was taken down in court. My only option was to complain to the Bar Association of Georgia. Their response took 18 months to get back to me, January 28, 2002, and said that Joan Davis had done nothing unethical. The final divorce decree document contains items that are designed to fail. For example, the document requires me to submit my completed tax return for the previous year by February 15th, long before it gets completed and well before the pertinent tax documents even reach me to get to my CPA. Therefore, I'm constantly in contempt. Another item designed to fail is the item that states that child support be based on my W-2s. However, I'm self-employed and have no W-2s. Therefore, they find it very easy to calculate child support based on overall business income on my tax returns and not my actual personal income. There are many more, and all are false, and all are designed to fail and put me in jail, and they know very well that I'm epileptic, and they play on that every time. On May 22nd, 2006, my ex-wife went to court against me to answer false financial contempt charges drummed up as a result of my oldest of my two sons changing custody without my knowledge whatsoever. I had no idea they were going to court. Judge Botiford said there would be a 90-day review of the court thing. This is why I had no idea that all this was going on. There was no signing of any rule niceties, no nothing at all. They stated that there would be a return, but they also stated that there would be a 90-day review with the counselor that was giving my kids heck at the time. So nobody said anything about any kind of coming back to court, so I didn't know any of this was going on. At the time, they decided to raise my child support without me being there or my attorney or anything at all. There was no way of knowing it. So all of it was delayed until February 22nd, 2007, when I was in my new attorney's office, Mr. Doug Davis, and learned that my ex-wife and her attorney, Marion Weeks, had gone to court on June 28, 2006, how many months earlier, and without myself present or my previous attorney, got Judge Botiford, who knew perfectly well that we weren't there, to create a final award ordering me to pay a lump sum of $109,606.75 child support and child support of $2,582 per month on top of that, and attorney's fees of $4,775. Botiford didn't sign the final order until the 19th, which is how my attorney found out about it. That is, 8 months after he had banged the gavel on the desk? I'm not even sure. By this time, I had logged so much time in Cobb County courts, that's over 7 years, waiting for my cases to be presented, that I came to know Georgia's Judicial Standard Operating Procedure all too well. Basically, Georgia's Judicial Standard Operating Procedure starts with charging a victim who has some money to steal with false charges. Next, Georgia's Judicial Standard Operating Procedure assigns inflated monetary damages to the litigation that the victim cannot possibly pay. Lastly, Georgia's Judicial Standard Operating Procedure arrests the victim for many false charges, including the false inflated monetary damages, and keeps the victim incarcerated until the false monetary damages are paid in full, which can almost never be paid, and the victim ultimately dies in jail. I wasn't going to let that happen to me. I'm epileptic, and they knew it. I knew I had to get out and pit one jurisdiction against another in order to find justice, so I went to work. In 2008, using a system of mathematics I called the shapes of things to come, now popularly known as chunking, I liquidated all my securities 10 days before the 777-point drop on the Dow in 2008. 6 weeks later, we moved to Maui. In 2010, January 2010, my ex-wife, her attorney Marion Weeks, and Judge Bodiford levied 2 office spaces I owned on Johnson Ferry Road in Atlanta, Marietta, worth over $450,000, though it was paying $5,800 per month to them, and gave it to Judge Bodiford's wife, who works in Cobb County Sheriff's Department, for auction in February 10th for $10,000 to a group of lawyers with whom they are financially very close. On January 11th, 2010, a policeman delivered my ex-wife's registration of foreign support order for the state of Hawaii. My ex-wife continued to want me to pay $209,000, which I did not have, or be incarcerated. As an epileptic seizure patient, I could not survive jail. She also wanted $2,582 per month for child support for one son, which is completely outrageous. By this point, there had been liens, garnishments, and levies on $1 million worth of property for a bogus $217,000 debt that was placed against me illegally without my knowledge at the June 28, 2006 hearing. On March 11, 2010, I received a certified letter from the Cobb County Sheriff's Office that my 2 office suites on Whitlock Avenue had been levied and were going to be auctioned on April 6th. The corrupt Georgia judiciary would attempt to pull the same stunt with Whitlock that they did with Johnson Ferry office. Bodiford levies and his wife auctions, which appears to be standard operating procedure and an obvious abuse of the system, but no one cares. Instead of the bogus $200,000 claim, my ex-wife went for the $23,000 in attorney's fees as well, and the prejudiced judge gave it to her. All of it being completely false because it had all been paid, stolen in the past because it was never due anyway to begin with. On April 16, 2010, I received a certified letter stating a re-garnishment of my tenant who was in the Whitlock office but moved out by exercising his escape clause I had written in his latest lease at his request the last time he signed a new lease. The re-garnishment was at the tenant's main address, not Whitlock Avenue, and was dated March 26, 2010 by hand. No one but my tenant, my attorney, and I knew of my tenant vacating the office space. Either they had a private eye keeping a very close watch on Whitlock, or they had inside information that was obtained sometime after the plaintiff's attorney's undercover paralegal spy left my attorney's office, which was another story that happened before all this occurred. On May 4, 2010, I received notice of a child abandonment hearing placed on the calendar for May 24th in Cobb County, 2010. This was a criminal warrant and the first time my ex-wife had gone criminal, something Judge Bodiford had been waiting to obtain for 10 years. Bodiford had placed neither time limit on my incarceration nor any parameters for me to get out, another fine example of their obvious attempts on my life knowing full well I'm a brittle epileptic. On May 10, 2010, I received yet another certified letter from Cobb County Sheriff's Office notifying me of yet another attempt at levy and auction of the Whitlock offices. On May 24, 2010, a different judge in Cobb County swore out the criminal child abandonment warrant and gave my ex-wife $15,326 more, which I immediately paid in order to even slow down the warrant. My attorney went to the judge and basically received no slack. Had I shown up in court, I would have been arrested for sure. My attorney said it was a good thing I wasn't there, so at least I escaped with my life for the moment. On Monday, June 21st, 2010, in the Cobb County Courthouse, my attorney had tried to present 15 motions to a different judge, but it was continued because the county attorney had a death in the family. The same county attorney signed a letter on his office's letterhead with his signature stating he would wait to auction Whitlock offices until litigation was complete. The ink wasn't dry on the paper and he had it up for auction. I had to pay an additional $30,000 as ransom to keep Whitlock off the auction block for 1 month. It was scheduled to be auctioned for July 6th, the first Tuesday of the month. Meanwhile, I had found a buyer for the auction for the Whitlock offices who would pay enough to end this thing. $119,000 went to my ex-wife, and Cobb County said I still owed her $72,000. On July 12, 2010, Bodiford signed a warrant for my arrest as a fugitive on the charge of abandonment of a minor child. After months of deferring thousands of dollars at $5,800 per month of garnished rental income labeled as arrearage and none labeled as child support, which was supposed to be $333 a month, ignoring the fact that it all went to my ex-wife every month anyway, regardless of how the money was labeled. On July 27, 2010, I was illegally arrested for the charge of, quote, charge under oath, which meant nothing, held in the 24-hour holding cell for 48 hours before being transferred to the main facility with no epileptic medication whatsoever. I had to pay $52,000 ransom to Judge Bodiford to be released August 5th, 2010. On August 10th, 2010, I was rearrested due to a false extradition claim by Bodiford. I was released on August 18th, 2010 for $5,000 bail and to reappear in court 60 days later after Maui had time to research. I returned 60 days later for court after due research by Maui had been completed. Mr. Taney, the Maui District Attorney, asked for all charges against me to be dropped with prejudice in my favor, never to be brought back to Maui ever again. Their research had uncovered 4 lies Cobb County Judiciary had told. They are fugitive to pay child support, abandonment of minor child, fugitive, and extradition. Maui demanded an apology from Cobb County, Georgia, and has yet to receive it. On March 24th, 2011, my youngest son signed his affidavit to come live with me in Hawaii, to which his mother immediately had her attorney file an illegal standing order keeping him in Cobb County indefinitely. I haven't seen him since Christmas 2009, regardless of the law, what gets filed, or how much gets paid. As of now, he's 18. He'll be 19 in August 2013. In late May 2011, I was notified of another $47,000 FIFE that Cobb County, Georgia has filed against me for attorney's fees that were paid years ago. They wanted to settle for $31,000, but not only did I not have the money, they wouldn't stop there. They continue because they have a court in Georgia that will file anything they want, regardless of validity, legality, or justice. By mid-June 2011, they decided to settle for $21,000, not including more FIFEs for attorney's fees coming from the main attorney for my ex-wife. They settled only because of my extreme TLE condition, but of course I don't have it. There's no way. And it's already been paid anyway years ago, and they're not going to stop anyway. On February 27, 2012, Joan Davis, my ex-wife's original attorney who swapped the original divorce decree back in 2000, was officially disbarred by the Supreme Court of the state of Georgia for many offenses that went back over 20 years, of which I don't know all that went on there. I don't know. On March 13th, 2012, I had a private investigator go down to the courthouse in Cobb County, Georgia, to retrieve a certified copy of the original divorce decree finalized in the year 2000. Civil action file number 99-1-7729-33. I've always contended that I never initialed any of the 20 pages of the document because they were supposed to be changed to the agreements made in mediation previously. My private investigator found the final divorce decree on record at the Cobb County Courthouse has no spaces for initials at the bottoms of any of the pages. The scanned copy I have here at the house from 2000 has spaces for the initials and my ex-wife's initials in the spaces where she was supposed to initial mine are absent. Therefore, someone between the year 2000 and now has swapped the original decree, which has spaces for initials and her initials on it, to a document that has no requirement for initials or on any pages without my consent or knowledge whatsoever. On April 17, 2012, the Hawaii Child Support Enforcement Agency, CSEA, held a hearing. I requested as a result of Cobb County's attempt at placing $14,637 on my credit report. Though Cobb County had temporarily reduced my child support on October 11th to the legal, they were continuing to try to place this illegal amount of $14,637 on my credit report, which they continue to try to grow at the illegal amount of $2,582 per month. The judge with the CSEA out here in Hawaii agreed that the CSEA hands are tied to the ex parte court order Cobb County and Judge Botifer generated back in 2006, completely illegal. The CSEA judge, the CSEA agreed to postpone. The CSEA judge agreed to postpone the credit report until a follow-up hearing could be held, at which time I can do all the court orders from Cobb County and writing on the website that I'm not supposed to do. I'm supposed to have, well, let's see, in this correspondence, I'm getting all messed up here. I went to Georgia's division of website only to find that all the previous activities 60 days before that, which goes back to, oh God, almost the year 2000, had all been erased. Someone back there in Cobb County had erased everything. So on May 8th, 2012, served a new summons to appear in Cobb County on June 26th. They now say, $40,000, and that I should be incarcerated in Cobb County Jail. All this has already been paid. They've also magically raised child support on a child that is now 18 years old to $2,828 per month. Obviously, I did not show up in any Georgia courtroom, and Hawaii says I should not. They know, Georgia knows perfectly well that I am epileptic and I have been diagnosed since 1993. Besides, they placed this case under Hawaii jurisdiction back in 2009. Cobb County is supposed to serve this stuff through my attorney, Doug Davis in Atlanta, and he's supposed to go through Hawaii's CSEA, Child Support Enforcement Agency, which is known as due process. However, Cobb County and most of Georgia ignored due process. Instead, Judge Flournoy swore out another warrant for my arrest on July 12, 2012, for failure to pay attorney's fees for my ex-wife's attorneys, which is completely bogus also. My attorney told me that Judge Flournoy said with a smile as he signed the warrant that, quote, Mr. Grund will never be back in Georgia, end quote. We all know that my ex-wife's attorneys legally contributed to the judge's political campaigns because it's legal for attorneys in Georgia to contribute to judges' political campaigns. Therefore, Judge Flournoy was simply returning the favor by signing this latest warrant for my arrest. Since then, we've also found that Georgia has been found to be the most corrupt state in the United States by the Center for Public Integrity.org. The hearing here on Maui on June 4th, in which Cobb County is currently trying to illegally put $14,000 in my credit report, resulted in the CSEA manually deciding to wait. Basically, they washed their hands of the situation, much like Pontius Pilate did. Later, they proved the Pontius Pilate scenario when the CSEA sent a letter stating that they no longer will support any further child support collections from the state of Georgia due to Zachary, my youngest son, becoming the age of 18 in last August, regardless of what the bogus and completely false Georgia divorce decree states. Hawaii has simply had enough of the Georgia's ignorance, lies, thefts, and deceit. In late August 2012, I received notice from a collection agency notifying me of a collection on a bogus $4,755 10-cent debt from the Georgia Department of Revenue from 2008 that was originally a mistake by the Georgia DOR, putting the wrong tax payments on the wrong tax returns, which was corrected in 2009, but yet is another mistake according to this. Another clear violation. So as we stand right now, I sit here in Maui with a current arrest warrant sitting on me where I don't dare go anywhere with fear that anywhere else they're going to have to serve that warrant because Georgia, the most corrupt state in the nation, still has it on their record. But Maui has the full story, and therefore they know that everything, all charges have been dropped with prejudice. Now, I understand that I have been advised that since charges have been dropped with prejudice, that we can take these charges now and turn it around and file suit in Georgia. And I wouldn't do it. I wouldn't even think of doing it at all if the ignorant hillbillies in Georgia would just stop. But they won't. They keep on going. They keep trying to steal money. They keep trying to ruin us. They keep trying to kill me. They keep trying to throw me in jail. So therefore, we're going to have to get them to stop somehow, and therefore we're going to do it legally. I need a lawyer who will do this on a contingency, and we're talking 7, 8 digits. So give me a call. Thank you very much. These corrupt judges have got to be taken out. We need juries to make decisions, and not these corrupt judges all the time. It's wrong to have them up there doing this. And it's time for term limits and judges to be taken out. www.americanchangeparty.com. That's one place to start. Just do it now.